1, Nicole Smith versus Jameson Cloud.
For the record, this matter is before the court for purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney John DQ representing the plaintiff's mother, Nicole Smith. Ms. Smith is present. In addition, Attorney Ron Bruce is present representing the defendant father, Jameson Cloud. Mr. Cloud appears to be present. Good morning, everyone.
Morning, sir.
Morning, Judge.
Morning.
The last order entered by this court in January of this year directed the defendant father to complete the intake with Family Counseling Shelter Services, and that supervised the parenting time would continue with that agency. Hopefully, we've made some progress in that regard. The parties have conferred with Mr. Pratt this morning. Mr. Pratt has recommended that the current order can remain in effect. And that either party may request review date after father is released from incarceration. Is Mr. Cloud currently incarcerated, Mr. Bruce?
No, Judge. He has an April 13 sentencing date. He's looking at some period of incarceration. He had an outstanding OW I-3, I believe.
What type of sentence is anticipated? Local jail sentence, prison sentence?
Possible prison, Judge.
Okay. All right. Has he completed the intake with Family Counseling Shelter Services? Have they started any supervised parenting time?
Judge, he has been experiencing time with the family member. I believe it's his aunt. She has been out of town the last couple of weeks, so he hasn't had any parenting time for the last, I believe, 2 or 3 weeks. But he has not been able to complete the intake. At this point, I don't think they're recommending that take place because there's a 6-week lag, and in 6 weeks, my client will have been sentenced. So I guess what my client's requesting, Judge, is that the court possibly consider his aunt being allowed to supervise him on an additional day, Saturday and Sunday for 2 hours as opposed to the 1 day. He is looking at some serious incarceration. He would like to maximize his time with the child. My understanding, child's having some behavioral issues. Hopefully dad can assist with that prior to this incarceration.
The court does note that the order was entered back in November of 2023, which should provide for parenting time for dad at the home of Linda White, I believe on Saturdays, for 2 hours of a period. Mr. DQ, what about that? Obviously, if your client, his mom, comfortable that Ms. White will not permit any alcohol use in the presence of when the dad is visiting the child?
I don't believe my client has any issue with her being a supervisor. The problem that's presented itself is we know that this incarceration is probably going to be prison time. Mr. Cloud hasn't done any of the stuff to move forward and try and facilitate more parenting time. That Family Counseling Shelter Services intake stuff, that's been on the table for many, many months, and he's done nothing to make that happen. He hasn't provided us or anybody with any counseling or other therapeutic notes or indicators that he's been getting any type of rehabilitation, therapy or treatment. So I think if the presently community mental health has an assessor, I believe, at Ms. Smith's house presently. It appears that the child is having some severe problems with ADHD. And part of that problem has been some acting out because of the visits with dad. The visits, I believe, have gone pretty well, according to Ms. Smith. So I would ask you to just maintain the status quo. And when he gets done with his sentence, we can come back and revisit this. Hopefully that will have him sober. He will have gotten some treatment while he's in wherever he's at, and we can approach this from a more therapeutic position.
Okay, Ms. Smith appears to have someone in the room with her. She's making motions to someone. Ms. Smith, we're in court right now. Who's in your room?
Community mental health.
Okay, I just want to make sure the child's not in your room. Well,
No,
she should not
no,
be
just
part
like
of these
Mr.
court
DQ
proceedings.
said.
Well, obviously, completing the intake, yes, all that would do is get Mr. Clott on the waiting list, but there's a long waiting list of a couple months, Mr. DQ. So the court would like to explore some additional time with Linda White. And again, this court can't dictate Linda White's schedule. Again, obviously, if dad's going to be incarcerated for a time, he should have be able to have some contact with his daughter or the child. I'm not sure if it's the daughter or son, I don't recall offhand, before he is incarcerated. So right now, is Miss White generally available on Saturdays?
Currently in Florida, Judge, but hopefully she's coming back in the near future.
I'm sorry, Miss Bruce, I didn't catch that. She's out of town.
Miss White's currently been on vacation. I believe she's in Florida. I think she should be coming back though. So when she comes back, we're asking that, time be Saturday and Sunday.
And who would communicate this to Miss White? Would it be Mr. Clott or Miss Smith?
It would need to be Miss Smith.
Aunt, but I'm not sure if she's an aunt and on which side of the family.
She's on Mr. Clodd's side of the family, and she would need to make the contact because there's not supposed to be any contact between Mr. Clodd and Miss Smith.
Okay, all right. So Mr. Clodd would be able to reach out directly to Linda White, then, correct?
Yes.
Okay, and it's just a matter of then Miss White informing she's available.
Correct.
Right. So. So currently, I believe the last order was sort of based on father parent time on Saturdays after counseling. Supervisor Linda White's house. Is minor child still engaged in counseling sessions on Saturday mornings?
They are changing to Wednesdays this week.
Okay. Well, let's set up a time on Saturdays and Sundays. Maybe so a couple of hours in each day. Mr. DQ, is that unreasonable?
Hey, Ron.
I defer to Ms. Smith on that, Your Honor. I'm not sure what the schedules look like, and I'm not exactly sure where the therapy has gone with the young man through this process.
Could we just do a longer time on Saturday? That way she doesn't have to have me there both days, so she can have time to herself on weekends.
Right. I'm going to, yes, that's not unreasonable, Mr. Clodd, but I'm going to have you talk with Mr. Pratt again, but Mr. Clodd, bite your tongue. I'm informed that you are not acting appropriately, and the court will not tolerate that. Do you understand that?
Yes, sir.
Okay. Ms. Pratt, you might take another 10 minutes with the parties and see what we can work out on some Saturdays. Mr. Clodd suggesting maybe a little long time on Saturdays, maybe 4 hours on a Saturday or something over the lunch hour. Maybe you can have lunch with the child. We're talking basically just another month or so till Mr. Clodd is incarcerated. The court believes he should have spent some time with his daughter as long as it's not creating issues for his daughter. Of course, we don't have Miss White to talk with right now, but obviously if Miss White is not willing to be involved in that, then the court can't control that. But if you could just talk with parties again for maybe another 5 minutes, please.
Yes, sir.
Thank you. Thank you, Mr. Pratt, for talking with the parties once again.
You're welcome, Your Honor. Get out of us.
Court is recalling top of page 1, Nicole Smith versus Jameson Clyde.
Once again, this Zoom hearing is being conducted for the purpose of reviewing defendant father's parenting time. The parties did address the court, then they conferred it once again with Mr. Pratt. Mr. Pratt has provided the court with the following revised recommendation that the current order remain in effect, and more specifically, that father shall have parenting time on Saturdays from 10 a.m. to 3 p.m. supervised by the paternal aunt. I think everyone knows who the paternal aunt is, that being Linda White.
Also, Your Honor, Ms. White would be transporting the child back to Ms. Smith.
Hey, do you want that in the order, Mr.
Yes,
DQ?
please. Yes, please. That's
Okay,
what's been going on, but the one of the problems with coming to this compromise was the amount of driving with the boys' other scheduled items. And so as long as everybody knows that, including Ms. Smith, I think it helps facilitate this whole process.
Very well. So Ms. Smith would drop off the child? to Miss White's home, and then Miss White would return the child.
Correct.
Okay, is that agreeable, Mr. Bruce?
Yes, Judge.
All right, so Mr. Brett, do you mind, I just have sends that Miss Smith shall deliver the child, and then Miss Linda White will return the child. With that clarification, Mr. DQs are inclined to agree with this revised recommendation.
She does, Your Honor.
So thank you. Mr. Bruce, this revised recommendation agreeable with your client, Mr. Claude.
Yes, Judge.
All right, Mr. Claude, obviously, when you get released, obviously, what the court suggests is, I don't know if you need an order for intake at Defense Correctional Services, but schedule that intake. Because if you're going to be gone for a period of time, we need to, slowly redevelop that relationship with your child. So that's what the court's going to do. So I don't know if you need an order to do that, but contact the agency, schedule an intake for supervised parenting time. You've got a history of orders here. You should provide that to them. That order will continue. So get back on track with that intake. They might require Ms. Smith to update her intake, and I'm sure they got the information from Ms. Smith if she previously contacted the agency. Get back in that waiting list. That's the right thing to do. Anything further this morning? Do you wish to barge your clients, Mr. Bruce and Mr. DQ at all this morning?
No, Judge.
No, Judge, I'm fine.
All right. All right. Well, good luck, Mr. Claude. Thank you again to Ms. Brad for your assistance. The court will adopt the revised recommendation.
Thank you.
Thank you, Your Honor.
Zoom out. Have a good rest of the day.
You too, sir. Thank you, Ms.
Thank
LaBrette.
you. Thank you.
Martin O'Neill. Wanted to give you a heads up. I wanted to give you a heads up that Mr. O'Neill's attitude has been very, very bad this morning. I honestly can't even get a word in edgewise because he won't stop talking. And he's being very rude. And he's being very rude again. So I made a recommendation. I'm not sure it's something that you're going to actually adopt. But I didn't know what else to do with the way that he's acting.
Yeah, I sure caused him before. I thought he settled him down, but David.
I brought that up to him, but he's back to the way he was before.
Okay. I have a 9:15. Rebecca wanted someone up here 9:15, so I'm going to take that first. It'll probably be quicker.
Yeah. Okay, so I'll have them wait in the waiting room until you're ready.
Okay, thank you.
Court is now in session. Add-on for Jolanda Spain versus Dwayne Wilkerson.
For the record, Dwayne Wilkerson has been elevated to this court from North Carolina Attorney Rebecca Hicks. This hearing this morning is being conducted via Zoom. Present is North Carolina Court Attorney Rebecca Hicks. Good morning, Ms. Hicks.
Morning, Your Honor.
And Mr. Dwayne Wilkerson, you are present on audio. Is that correct?
That's correct.
All right. Ms. Hicks, you're asking the court hold Mr. Wilkerson in contempt of court. Is that correct?
That is correct, Your Honor.
Can you provide a little background about Mr. Wilkerson's case?
Certainly, Your Honor. In this matter, there's a current monthly support obligation of $641 per month. The current arrears balance is $26,039.91. We received a $20 payment yesterday and two $10 payments in the month of February. That's all the payments we received after he made a $1,000 payment at the end of December so that his previous bench warrant would be pulled. He did claim today to Ms. Brower that he mailed a motion to modify support to the courthouse 2 weeks ago. But that's only, it's not been scanned in. There's no verification that one has been received. I do believe he stated that he mailed that in along with a fee waiver request.
Okay. All right. Has he been referred to the Attorney General's office? He should be charged with felony non-support. $26,000 in arrears, Mr. Wilkerson. You are lucky you're not being charged with a felony criminal charge of non-support. You go to prison for that. In any event, of course, if you're charged with that, you can go to prison. The most this court can do is 45 days in jail. So do you understand, Mr. Wilkerson, you're being charged this morning with civil contempt of court for failure to pay child support. The maximum sentence being 45 days in jail. Since there's possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all that?
Yes, I do.
Are you asking for a court-appointed attorney?
I mean, I don't understand what's going on. You saying that I'm facing jail time?
Mr. Wilkerson, yes, you're moving closer and closer to jail later this week. So do you want an attorney?
Oh yeah, of course I'll take an attorney.
All right, the court's going to order that you personally appear. I need to ask you a few questions to qualify you for court-appointed attorney. Are you currently employed?
No, I'm not.
How do you support yourself?
I do odds and odd jobs here. I sewer snakes and all of that stuff. Backup drains here in Detroit.
Okay. So you are employed, but were you self-employed?
Well, basically self-employed. It's like you get paid on the table when someone calls you if they got a backup or something. Unfortunately,
Okay.
being here, it's so much competition, so it's not like it's every day.
So you're a self-employed plumber, is that correct?
No, I'm not a plumber. You don't need to have a plumbing license to snake someone's main drain.
Okay, so you're in the sewer business.
Well, no, I wouldn't say I'm in the sewer business. This is what I do to make some money.
Okay. Well, you need
Clean
to
out basements.
right. So, how much you take home per week, average?
So I don't know. It's about $450. Sometimes $700. I don't know. It's just hard to tell. And that's not consistent at all.
Do you own any property of any value, such as an automobile or bank accounts?
Well, no, I don't.
All right.
And my house is in somebody else's name. It's not just my house. It's owned by another person as well.
All right. Court will grant your request for court-appointed attorney.
Appreciate it.
Mr. Wilkerson, the court I'm going to give you a couple days to get some money together. I'm going to order you personally appear before this court on Friday.
Well, I'm not going to get any money together. How am I going to get any money together? I can't even get a ride to work. I'd have suspended license.
Okay. Mr. Wilkerson.
And I never had that before. But I want you to know, sir, that I take care of my kids' clothes, haircuts, phones. I just bought a $200 phone the other day from the little money that I did make. So we're not going to get it misconstrued. And I understand that, yes, I have an obligation here, but I have been trying to pay. Okay?
Mr.
I'm not running away from nothing.
Mr. Wilkerson, when you're done talking, let me know and I can talk.
Oh, I'm not trying to talk over you. I thought I was able to talk. I apologize. Sorry about that.
Okay. If in fact you are buying all these things for the children, then you have Miss Spain come down and waive some of these arrearages. You have no obligation to buy cell phones for the children or pay for the haircuts. You need to pay child support through the Middle Crime Friday of the court. That's what the court order says. So that what you can do to help yourself, I'm offering you a suggestion to have Miss Spain come down and waive some of these arrearages. That's going to help you. The court's going to order you personally appear. Mr. Wilkerson, the court's ordering you personally appear on Friday this week. That's March 8th, 2024, 11:15 a.m. And the court's going to order you bring $1,000 or a toothbrush. I'm suggesting that, Mr. Wilkerson.
Well, I'm gonna bring the toothbrush. I can tell you that right now, sir. I don't have enough $1,000 to give you, so I'll bring my toothbrush. I'll be ready to go Friday.
Okay, 11:15 a.m.
And what time you say I got to appear? What time you say I got to appear Friday?
County Courthouse.
What time?
11:15 a.m. We'll get you over there before lunch.
I'll be there. Thank you a lot, sir. Appreciate you.
You're welcome.
Threaten me with jail. Is that all for me?
Yes. Let me get a cell number for you because I'm gonna have the court-appointed lawyer talk with you ahead of time. So give me a cell number they can reach you at.
Yeah, 317.
So, Mr. Wilkerson, I'd rather you stay out working. You need to get a more steady job. If you can come up with $1,000, the court's inclined to.
I don't have another $1,000. I got other personal problems. I don't have another $1,000. I'll see you Fridays. Am I done?
Okay. Yes, you're all set. I'll see you on Friday, 11:15.
You're not going to threaten me, sir. I'll see you Friday.
Okay.
Are you done with me?
Yes, you can zoom out, Mr. Wilkerson.
See you later.
Court is now in session. Middle of page 1, Hazel Merritt versus Martin O'Neill.
For the record, this matter is before the court for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. Present is Attorney Alex Goldman, representing the plaintiff mother, Hazel Merritt. Ms. Merritt appears to be present, but she's muted herself. Is Martin O'Neill present on audio?
Yeah.
All right. Good morning, Mr. O'Neill.
Good morning.
Mr. O'Neill, I'm informed that you would not behave rationally when you conferred with the front of the court. You shoot yourself in the foot when you yell and scream and you talk over people, Mr. Merritt or Mr. O'Neill. We've discussed that in the past. You've got to control your behavior. Do you understand that?
Yes, Your Honor.
Are we going to behave with this hearing this morning, or if you're going to start yelling at the court, then we're done?
No, I'm acting like I have some sense.
I'm just suggesting to you, when you meet with the front of the court or any court representatives, if you behave yourself, you're going to get much farther. And people will listen to you. But when you start yelling, people will shut you right down, Mr. O'Neill. I'm just telling you that. So in the event, the parties have conferred with Mr. Walker this morning. Mr. Walker has provided the court the following recommendation. Recommendation is the ex parte order of November 29th be reinstated until further order of the court. For the record, the ex parte order suspended defendant father's parenting time. Is that correct?
Yes.
All right. What's going on, Mr. O'Neill?
Well, I guess Elijah had 2 appointments, right? She had 2 appointments, and when she gave me the appointments, I already had
What has changed since we're last in court on February 6th? What's happened in the last 30 days?
Hey, really nothing changed. Elijah's doing good in school. She's going to school every day. She's reading. She's learning her spelling words. And she's going to bed on time, and she's doing everything right. And I guess I got this exportation is because I forgot 2 doctor's appointment, but which she gave them to me like 1 or 2 days unnoticed. So like I couldn't keep up with that because I had to get her in school. She has to be in school. She hasn't been sick. She hasn't, like, nothing has not been wrong with her long as that I have her. So I just don't understand why is they trying to put this ex parte back on me, and I haven't did anything wrong. How mom is going to schedule appointments on my week or the time that I have her? I don't understand that. And then the phone call situation, I've been trying to get Elijah to call her mom. She said she's not ready to call her mom. Miss Hazel called the police out here and told the police that I was withholding her phone and this and another. The police talked to Elijah, and Elijah had told the police that she wasn't ready to call her mom. She brought her this phone, and Elijah don't even touch this phone. This phone lay right next by her. So I just don't understand how y'all trying to put this ex parte back on me because I missed 2 appointments, which she gave them to me like 1 or 2 days before. I guess I don't know. It's just
okay. So
it's just too.
Okay, Mr. O'Neill, I got cases every 15 minutes, so I'm trying to got to be succinct here. So the only change has been you missed 2 medical appointments for your daughter. Is that correct? Since we were last in court.
Yes, sir.
Okay, who's the appointments? Who were they with? Who scheduled them?
It was a dentist appointment and then a pulmonary, whatever that, I don't even know what that is.
Okay, why'd you miss the dental appointment?
One, I didn't have a ride for her because my girlfriend had to work, and then I didn't have insurance to go all the way out there from our car, so we didn't go.
Okay, did you reschedule
And
it?
plus it was a little, huh?
Did you reschedule the dental appointment?
I was trying to reschedule it, but when I was trying to find her another doctor's appointment, I had called her doctor, and her doctor had told me that they had dismissed Miss Mary and her kids from the doctor's office for
Right,
missing an appointment.
Mr. Neal, the question is, did you reschedule the dentist appointment? If you said you didn't have transportation, first of all, who scheduled the appointment? Did you or did Hazel schedule that appointment?
Hazel, I don't. I guess Hazel scheduled it.
Okay, and when you didn't have transportation, did you reschedule the appointment? It's a simple question, either yes or no.
No,
Why?
because I just got insurance on my
Okay, now
car.
you have insurance. Hold on. Now you have insurance. Why didn't you reschedule?
Because I'm so confused about this doctor telling me about Alasia doesn't have a doctor anymore. So I was trying to face her to get a doctor.
Mr. O'Neill, let's talk about the dentist. You missed a dental
I don't
appointment,
know
you had
any-
insurance, you never ride. Once you got insurance, did you reschedule the dentist appointment? Let's not talk about doctors, let's talk about the dentist. Did you reschedule the dentist appointment?
Yes, we're gonna schedule it.
Yes, I rescheduled it.
Okay.
I'm going to.
Off-camera participants.
Okay, you're going to.
No, it's not, dude.
Mr. O'Neill, you gotta do that yesterday. You gotta do that immediately, you reschedule that.
Okay, but listen, how can I do anything when it's like I got all type of stuff to do with Alasia. She's doing counseling. She had her IEP. She have a meeting on the 7th that I had to go to. Well, not on the 7th. On the 7th of this one that I had to go to. I had to go to another meeting. I'm trying to set all this stuff up, but I'm in the weeds because she really need a doctor. And when I called the doctor, they said that they dismissed them from the doctor. So how do I know that she got any other doctor? Because Miss Merritt is not telling me this. She's not telling me anything about her doctors.
Well, you schedule an appointment with it. First of all, reschedule a dentist appointment. Mr. O'Neill, if you can't handle these things, then obviously the child should be with mom if you can't handle these things. If you want to be have a regular parenting time, you need to take care of these things. All right, so we hear from Mr. Goldman. Mr. Goldman, what's been the change circumstance the last 30 days that we just flip-flop things with this poor child going back and forth, back and forth?
I agree, Your Honor. And I think that the flip-flop schedule was a drastic flip that my understanding was based off of a phone call that friend of the court had with the school principal. That's why I've included the attendance records to show that all the alleged absences under mother's care are excused, or a vast majority of them. So I think that the current parenting time schedule is punitive for no reason. I think that Miss Merritt has always provided for the child's medical appointment needs, gets her to school when she's able to go to school. So we're requesting that based on that, that we return to an equal parenting time schedule. I do want to add, my whole involvement is based on the ex parte, and we've been waiting for the CPS report. I just received that at 4:45 yesterday, and I would just like more time to review it and also provide a copy to the court. My understanding is that the court has not received a copy either.
Right. Obviously, when mom schedules a dentist appointment, she got scheduled on her time.
Well, she did, Your Honor. She scheduled it on her time, and then then all her parenting time was removed at the last hearing. When she dropped the child off on February 11th, she included a handwritten note that there was an appointment on February 13th. Father then took it upon himself to just not take the child to that appointment and not reschedule it.
All right. The court, the two of you need to start communicating for the best interest of your child. You're making life difficult for each other. You're making it difficult for your daughter and each other. Do you hear me, Mr. O'Neill and Miss Merritt? You're making life difficult for each other and the child.
Can I say something right quick, Your Honor?
No,
Please.
no, Mr. O'Neill. What the
All
court
right.
believes that back in October 2023, the two of you agreed upon joint legal, joint physical, week on, week off parenting time. The court's going to reinstate that. So the week on, week off, the child will continue to attend. I mean, and there should not be really excused absences, Mr. Goldman. I'm not going to get into and spend a bunch of time in terms of why there were a lot of absences. Maybe they're excused, but the child needs to be going to school. Schedule the doctor's appointments maybe after the school day or something.
Your Honor, what if the child has COVID?
Okay, well, do we have documentation on COVID? But we're going to go there. The court's going to reinstate what the parties agreed to back in October, not even 6 months ago, 2023. So the court's going to go back to where we started some time ago, Mr. O'Neill and Ms. Merritt, week on, week off parenting time. The exchanges at the Dundee Police Department. And I don't recall when we exchanged. Was it Sunday at 6 o'clock?
I think that's correct. I think it's Sunday to Sunday at 6 at Dundee Police Department.
All right. So we're going to exchange on this Sunday at 6. Mr. O'Neill, you can bring your daughter out to Dundee Police Department. The child will go with mom for a week. And mom, you've got to understand, you now live in Lenawee County, but you've got to make sure the child gets to the Arborwood School. And can you do that? Ms. Merritt? You need to unmute yourself.
Sorry, I was trying to unmute myself. I do make sure she gets to school when she's not sick and is able to attend the school.
Okay. Well, if she's sick, you need to take her to the doctor that day.
What is that?
Oh, I do.
Your Honor,
So
the
fact
exhibit
she's
I
on
provided
call is
yesterday.
I think she got Munchausen's by proxy.
Mr. O'Neill, stop.
Okay.
Stop, Mr. O'Neill. Miss Merritt, if she says, I just don't feel good, get her to the doctor's office. You're not going to take her to school and she needs to go to the doctor's office.
I do.
Your Honor,
Okay.
I did attach, I gave that exhibit to your chambers yesterday. It's got a lot of doctor's notes in the back.
It's very small print. I don't know if my glasses can pick up all these prints. I see just a lot of dots. And I see
The
the word
last 4
EX.
pages are doctor's notes.
Okay. All right. Okay. So again, the court's going to reinstate week on, week off parenting time as the parties agreed back in October 2023. The exchange will occur at the Dundee Police Department at 6 o'clock on Sundays.
Can it start today?
It started on Sunday. Mr. O'Neill, do you have any questions?
Yes. Is there any type of way that we can get mom check for Munchausen by proxy? Because that's what it seems like.
How does the court check that? Obviously, if you feel that she's abusing this child by having unnecessary exams, yes, obviously it's a concern. This child can't be examined, especially if it's a alleged sexual assault exam. We can't be putting a child through that unnecessarily. Yeah. But you need to talk to an attorney about that, and you need to maybe file a motion for a psychological evaluation, Mr. O'Neill. But at this point in time, let's try this week on, week off. Mr. Walker, do you think we need a review date in a couple months? Or Mr. Goldman, any thoughts about a review date?
Your Honor,
it seems like these parties are having a difficult time communicating together.
I understand, Your Honor. I just think that the importance of the underlying allegations involved in the ex parte haven't been fully explored because we've been waiting for the CPS report. I got that last night. If I'd gotten it 3 days ago, we could have addressed it today, but I just think that the court deserves to have time to review that.
Your Honor,
I have all 17 pages. All 27 pages.
on the front of the courts, it's okay. On the front of the court side, Your Honor, we did receive not the full report, but a smaller report that states that there was no preponderance. I know Mr. Goldman says that there are things in the larger report that may have significance, but the report the front of the court did receive did state that there's no preponderance. They closed the case.
Okay. Well, we can, Mr. Goldman, are you requesting a review date in 30 days, 45 days?
30 days, Your Honor.
All right. We can set a review date.
And while we do that,
Mr. O'Neill, it's very important. You have to protect your daughter. If there's some allegation that there's a stepchild or your girlfriend's child that's inappropriately doing things inappropriate to the daughter, you need to make sure that you are present. Your daughter is protected from everyone in this world. So we'll set this for review then in about let's see, End of April.
23rd is the 23rd, okay.
How about April 23rd? April 23rd at 2 o'clock, you available, Mr. Goldman?
Yes, Your Honor. April
Okay,
23rd
we'll
at 2?
time. Yeah, 2 o'clock. Mr. Walker, if we could add the court review parenting time, April 23rd, 2 p.m. Again, the court will reinstate week on, week off parenting time. That will begin on this Sunday, 6 o'clock. The parties will be at Dundee Police Department, Sunday to Sunday. And that will begin, of course, this Sunday, which is March 10th.
And
This morning, Mr. Goldman,
Sorry, Your Honor?
do you have anything further this morning?
No, Your Honor.
All right, Mr. O'Neill, anything further?
yes, I have just one more question. Where did you say I have to go for that Munch housing by proxy? You said
Maybe an attorney can suggest you probably need to file a motion and lay out all the evidence that you think would support a psychological evaluation. They need to determine who's going to pay for the psychological evaluation of Miss Merritt. It's
Okay.
complicated, Mr. O'Neill. It's not as simple as the court just ordered it. Somebody's got to pay for it. It's very expensive.
Oh, I ain't worried about it.
You need to get together documentation of all the alleged medical appointments that you claim that mom made for your daughter and that they were without merit. You know, get
And about her being sick too, right? And about her being sick too, right?
Get proof, documentation.
Okay.
That the doctors are saying there was an unnecessary appointment or not as necessary. And obviously, you want to exercise caution. If in fact there's an issue, you want to have a doctor at least look at the child, evaluate the child, Mr. O'Neill. But if in fact the child's going through a SANE exam or a sexual assault exam, that's invasive and that's a little different. I don't know whether that's occurred, but you need to get the documentation and proof. I'm sorry, Mr. Goldman, you had something else?
A very small thing, Your Honor. To reschedule the dentist appointment is going to be $35. I'm assuming that Miss Merritt's going to be responsible for that, and we're just asking that she be reimbursed for that.
No, because it's gonna be on her time. She can't schedule nothing on my time.
But she has to incur a $35 fee.
So, Mr. O'Neill, the court's going to order that you reimburse Miss Merritt $35 for that missed appointment. You were aware of it, and you just didn't have the transportation, so it's $35, not a big expense. The child was with you at that time. The court gave you possession of that child. So the court's going to order you pay your $35. Okay? And that
Yes,
will
sir.
conclude this matter. We'll see everyone back here then on April 23rd at 2 p.m.
Thank you, Your Honor.
Right?
Munch house by
Okay, you
proxy.
zoom out, Mr. Goldman. Mr. O'Neill. Matters before the court for purpose of reviewing parenting time primarily and any other issues. This hearing is being conducted via Zoom. President Attorney Alex Goldman representing the plaintiff mother, Hazel Merritt. Mr. Goldman is present. Good afternoon, Mr. Goldman.
Good afternoon.
Hazel Merritt, are you present in audio?
Yes, I am.
Good afternoon. Is Martin O'Neill present in audio?
Yes.
All right. Good afternoon, Mr. O'Neill.
Good afternoon.
Parties have conferred with Ms. Patrick this afternoon for the front of the court, who has provided the court the following recommendation. Presumably, parenting time will continue as previously ordered. It's further recommended that in order entered that the minor child shall not be taken to any correctional facility, to any prison or jail without father's permission. I suppose it should be both ways. Dad should not be taking the child to a correctional facility without mom's permission. So the child should not be taken to any correctional facility without the permission of the other parent. Consent. Further, that the $35 expense for a missed dentist appointment will be added to the front of the court account, and the defendant father will pay that to the front of the court. The court recalls back on March 5th, the court ordered that Mr. O'Neill reimburse Ms. Harrod $35 for that missed dental appointment, and apparently Mr. O'Neill cannot do that, so it's to be added to the child support. And further, that the minor child shall have access to her phone and charger. That's a recommendation. Mr. Goldman, is this a recommendation agreed with your client this afternoon?
Yes, Your Honor.
Right. Mr. O'Neill, do you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting this recommendation?
No.
Okay. You don't have $35. You can pay this expense to Miss Merritt.
Well, I had the $35 and I got Alicia hair done So I paid the lady the $35 like she told me to. So now she need another $35. I have no problem doing it. I just want to take care of my child and stop coming to court. That's all I'm gonna do. I don't wanna argue or none of that.
Mr. O'Neill, Mr.
Yes.
Hold on, but 6 weeks ago, you wanted to pay $35. Why had you pay that? It's not $350, it's $35.
Because I only have one income. She have a bunch, she got all that shit over there.
Okay.
Like, come on,
That
man.
answers the court's question. I don't want to open a can of worms. I just was wondering.
Yeah,
if you
don't.
Pay $35. So in other words, that $35 that you owe for the dump will be added to your front of the court obligation. Understood?
Yes, sir.
Understand that, Mr. Martin? Mr. O'Neill, I'm sorry.
Yes, sir, I do. What I don't understand is, can I say something?
Well, do you have a question?
Yes, I do.
Okay, what's
I
your
have a
question?
My question is, why is it that Miss Mary get all the benefits for Elijah, but she calls me for money and gas money and tells me that she's going out for child support because she can't afford to take Elijah back and forth to school and all this. Like, how is we going to like break this up so when she's here, she can have something coming in here instead of her just getting all the
Okay.
benefits.
Mr. O'Neill,
Like,
you have no obligation to give her directly money. You have no obligation to pay for your daughter's haircut. If you choose to do it, it's the right thing to do as a parent. If you say, I can't afford it, I'm not going to do it, you have no court order that says you got to pay for her hair appointments.
No, that's what I did with the money. I took the $35 and I gave it to the lady.
That's good. But Mr. O'Neill, you're not ordered to do that.
Okay.
You're not ordered to do that. So that was your generosity as a parent. So it's a good thing. Anything further, Mr. Goldman?
No, Your Honor.
Do you need
So you just gonna ignore what I just asked you?
You need to voir dire Miss Merritt, Mr. Goldman, or is that not necessary?
I don't believe it's necessary, Your Honor.
All right, Mr. O'Neill, did I answer your question?
No, you didn't.
Your Honor.
Okay, Miss Patrick, perhaps you can
I
answer
believe
the
I can
question.
help. I can help answer Mr. O'Neill's question. Mr. O'Neill, if your question is about the DHHS benefits that she's receiving, then you would.
And Social Security.
Okay, so you would need to go to the Department of Human Services on Telegraph Road and discuss that benefit with them. This court has nothing to do with those benefits. We don't provide them and we don't see them. Also with Social Security, you have to go talk to the Social Security agency. This court doesn't have anything to do with either one of those benefits.
Okay.
Okay?
Yep.
All right, thank you, Miss Patrick, for answering that question. All right, that will conclude this matter. I'm pleased to hear, Miss Merritt, Mr. O'Neill, that you're working out parenting time.
Yes, sir.
And I understand it's an expense for Miss Merritt to transport the child to Arborwood schools, but she was the one that chose to move out to the west part of the county. So that will continue. All right, now everyone can zoom out. Have a good rest of the day, everyone. A copy of this will be mailed to Mr. Goldman as well as to Mr. O'Neill. Good job. Okay, you can zoom out. Have a good rest of the day.
Thank you.
Thank you, Your
Do
Honor.
we have a DNA test result?
We do, Your Honor. He is the father, so I have a rec in the queue, but mom's not agreeing to any parenting time, so I scheduled them to facilitate with Mr. Walker because he's so good at what he does.
Okay. Do you have a copy of the DNA test report?
I do not, Your Honor.
Okay, I'm going to want to see that before I enter any order this morning. So can I have Savage, does he have a copy of that? If someone could scan
I'll
it
have
to the
him
court?
email it. Yep, I'll have him email it. Give me just a moment.
And Martin O'Neill must be hard of hearing or something. He talks so loud.
Have you noticed that when people can't hear, they think they
For the record, this matter is before the court for the purpose of reviewing DNA test results. This hearing is being conducted via Zoom. The president is Attorney Barry Savage, representing the defendant, Scott Corns. Mr. Corns appears to be present. Is Ashley Kuntz present on audio?
Yes.
All right, good morning, Ms. Kuntz. Good morning, Mr. Savage.
Good morning.
The court just received from Ms. LaPrade a copy of a DNA test report from DNAcenter.com. dated February 29th, 2024, which indicates a significant probability of paternity on the part of Mr. Corns relative to the minor child Isabella Kuntz, 99.9999% probability of paternity. And Ms. Kuntz, have you received a copy of this DNA test report?
Stephanie did email it to me because I didn't get it, and then she ended up emailing it to me. I'm still trying to bring it up, and it's just loading, so it might take a minute until I'm off the phone, and it might bring it through then, hopefully.
Okay, I want you to review this report and advise the court whether or not you have any objection to the court entertaining this report to determine paternity on the part of Mr. Corns. Mr. Savage, obviously you are requesting that the court adopt the result of this DNA test report. Is that correct? And determine Mr. Corns to be the biological father of the minor child, Isabella?
Yes, Your Honor.
Okay, we'll wait for Ms. Kuntz to review that report. Everyone would have received this before today, so we can timely address this issue, which was set for 9:30, now being almost 10:20.
All it's doing on my end is
Ms. Kuntz?
yes.
Did you receive a copy of the report?
It is just loading. That's all it keeps doing is loading for me. I backed out of it, went back into it.
Your Honor, it's my understanding, though, that Ms. Kuntz was not questioning the paternity. I believe it was just Mr. Corns. So in our discussion, she was not questioning the paternity.
Thank you. Is that correct, Ms. Kuntz?
Correct.
Okay. I'm just indicating for the record that this DNA test report does indicate, and this is pretty standard, a significant probability of paternity, 99.99999%. It certainly verifies that to this court. It's a business record, it's up to admission, and it certainly indicates to this court that Scott Corns II is in fact the biological father of Isabella. And even though you don't see that in front of you, are you willing to acknowledge that Mr. Corns is in fact the biological father of this child?
Absolutely.
All right. Ms. Kuntz, could you please state your name and current address for the record, please?
Ashley Kuntz.
Sir, we have an address for you. Have to change your address?
No.
I'm sorry. So we got the correct address. All right. Ms. Kuntz, do you specifically admit and acknowledge that Scott Corns II is in fact the biological father of your daughter, Isabella?
Yes.
Do you have any questions for the court?
No.
Okay. Mr. Savage, do you have any questions of Ms. Kuntz?
No, I do not, Your Honor.
All right, Mr. Savage, if you can do a voir dire, Mr. Corns, please.
Scott, you've seen the DNA report.
I have.
And you satisfied that you determines that you are the father of Isabella, the daughter to which Ashley Kuntz gave birth.
I do.
And you make the statement under oath.
Yep.
All right. Thank you, Mr. Savage. Based upon the testimony, based upon the DNA test report that's the court is in receipt of, as well as the testimony of the parties, the court finds and determines that Scott Corns II, the defendant in this matter, is in fact the biological father of the minor child, Isabella. The parties have before with Mr. Pratt, who is part of the court's fine recommendation.
Pardon?
Mr. Pratt, part of the court's fine recommendation that the parties shall share joint legal custody of the minor child with physical custody to the plaintiff mother. What that means, Ms. Kuntz, is that two of you share equal in a major decision concerning the welfare of Isabella. Let's say Isabella needs an elective surgery. You must inform and consult the father for things like that, of that nature. Major decision concerning her welfare, health, education, religion. You understand that? With physical custody being awarded to you, so you make the day-to-day decisions.
Yeah.
Further, it's recommended that the issue of child support be referred to the front of the court for formal investigation recommendation. with each side having 21 days in which to object to any recommendation, or the start date for that child support should be March 1st, 2024. Further, that the party shall mediate with Mr. Joshua Walker on March 28th, 2024 at 1:30 p.m. via Zoom regarding parenting time. That is a recommendation. Ms. Kuntz, do you understand the recommendation of Ms. LaPrade this morning?
Yes.
Do you have any objection to the court adopting this recommendation?
No.
Okay. Mr. Savage, does Mr. Corns have any objection to the court adopting this recommendation?
No.
Okay. All right, the court will adopt the recommendation, finds it to be appropriate and best of minor child. Obviously, Ms. Kuntz, Mr. Corns is entitled to parenting time to develop a relationship with this 4-year-old daughter. It's important for your daughter's welfare to have a relationship with her father. I understand there is a long distance. Mr. Corns lives in Marquette, Michigan. Is that correct, Mr. Savage?
He lives out in the Upper Peninsula. And he went off.
Obviously, that makes things challenging.
Yeah.
For personal contact. I don't know if Mr. Corns maybe has relatives down him in this side of the state that he can come down during the summer months. But in any event, that can be discussed with Mr. Walker on March 28th at 1:30.
Mr. Corns' parents, which would then be the grandparents, Isabella, also live near Mr. Corns in the Upper Peninsula. So.
Okay, so it's pretty hard to send a 4-year-old up there.
Pardon?
It's pretty difficult to send a 4-year-old up there who doesn't have any relationship with their dad to send up with strangers. I think Mr. Corns needs to make some arrangements to come down here to have some initial contact with his child, so the child knows who her father is.
Yeah, and I think there has to be initial contact. I agree. And then
I think it needs to go very slow, and they need to meet slowly before it goes as far as like her going to spend like a weekend up there or any time overnight with him. I think they need to get to know each other before the overnight start.
I
just
agree.
So she gets comfortable and he's comfortable as well.
All right, I agree. Everyone appears to agree with that, Ms. Kuntz, but hopefully Mr. Corns can make arrangements to come down this area.
I can.
Rather than driving the child up 5 hours, probably about a 5-hour drive. In any event, the court will adopt the recommendation. The two of you maybe can make some progress with Mr. Walker and start at least slowly. And obviously, and then we can always review child support, in a few months from now or 6 months from now, but let's maybe get something started where Mr. Corns could have some contact and meet Isabella. All right, anything further this morning, Mr. Savage?
Nothing further. I think we meet with the facilitator on the 28th at 1:30, and I think that will be important. And then I think we'll also have the issue of child support will have to be resolved. So,
okay,
I think the friend of the court plays a role in that. If I'm wrong,
that's correct. I don't know if they have the recommendation ready by March 28th or not.
Your Honor, Mr. Walker can assist with that during mediation.
Okay. Okay. All right. If there's nothing further, that will conclude this matter. The court will adopt the recommendation. Copy mailed out to everyone. Thank you, Mr. Savage. Have a good day, everyone. Thank you, Mr. Brad.
Thank you, Your Honor.
There's no session, top of page 2, Margaret Smith versus Lonnie Stump.
The record of this matter is before the court for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. President Attorney Ron Bruce representing the plaintiff, Mother Margaret Smith. Ms. Smith is present. In addition, Attorney Christina Hills is present representing defendant father Lonnie Stump, and Mr. Stump is present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred with Ms. Patrick, who is by the court following recommendation that plaintiff father shall have parenting time every other weekend, Friday at 5 until Monday at 7:15 a.m. Also every Wednesday, 6 p.m. overnight until Thursday morning, 7:15 a.m. Parties shall use app close for all communication, and communication shall be regarding the minor child. Parties shall use the defendant mother's school district for the front of the court holiday schedule. as a recommendation. Ms. Sills, is this recommendation agreeable with your client this morning?
Partially, Your Honor. We are asking that in light of the difficulties the parties have had with co-parenting recently, that the court order the parties to attend the SMILE program. And also with regard to the midweek overnight, the Wednesday overnight that's been recommended, my client is asking that the court not do Wednesday overnight, but do Monday overnight instead. If it's tacked on to his weekend, that is less back and forth and a little more stability for Briar, who is just 18 months old. And also the midweek is quite a bit more difficult. And I know this is not about my client, it's about Briar. But the midweek is more difficult for him from a work standpoint because of various projects that he gets involved with. In his experience, plant outage issues tend to occur more midweek, and the Monday would offer him a lot more flexibility to maximize the time that Briar is able to spend with him and vice versa. But particularly, again, lessening the back and forth for Briar, minimizing those exchanges. We are fine with all the other aspects of the recommendation. We would ask, and I know it sort of goes without saying, but we would ask that it be in the order again, that parenting time can be additional times that the parties could agree to. So with those additions and modifications, that's what we're asking for.
Very well, certainly, if the parties have not completed the SMILE program, the court will order they complete the SMILE program. And we can also include in this order that any the parties shall have such additional parenting time as the parties can agree. So Ms. Patrick, you can add that. And with respect to the weekday parenting time, obviously we're trying to minimize back and forth for the child. Should just be then only the Mondays that he has weekends. Mrs. Hills?
That's what we're requesting. Optimally, he would like to have the Monday and Tuesday overnights and a standard 2-2-5 schedule. We understand that's not what Ms. Patrick is recommending at this time. So with the addition of the language about other times as the parties could agree, he would request the Monday overnight because of the additional flexibility he has with regard to work on Mondays, as well as minimizing the back and forth for the child, because that Monday would be tacked on to his weekend, every other week.
Okay, so if court understands, you're suggesting we eliminate the every Wednesday and instead include the alternating Monday overnights, correct? The Mondays that tack on to his alternating weekends.
It would be every Monday overnight instead of every Wednesday overnight. So it would not eliminate, all of the back and forth. There would still be an isolated Monday every other week, but it would eliminate an exchange on his weekends because it would be the Monday would be tacked onto his weekend.
All right. So you're requesting that every Monday overnight.
Yes, please.
In lieu of the Wednesday overnight. All right. Mr. Bruce, your client's response?
Judge, I think my client already completed the SMILE program previously as part of this case. In regards to the Monday, we're asking the court to keep it on a Wednesday. Basically, what they'd be doing is taking the child away from my client from 7:15, Monday morning till 6 p.m., which when the child would have had him on Wednesday. So basically, that entire day where the child would have been with my client will instead be with the paternal grandparents. Not that my client has a problem with the grandparents, but she would rather exercise that parenting time for herself. And it would be an extended period of time away from the child if, my client didn't have her, Friday, Saturday, Sunday, and Monday overnight. She wouldn't see the child for a good 4 days. Child's only 18 months, Judge. Child breastfeeds. My client thinks that Wednesday would be the better day. Like I said, she doesn't want to sacrifice all that time. She's a photographer, Judge, works 3 or 4 hours a week. Any of this weekend time is time spent with her. We would ask that the court keep the Wednesday date.
Yeah, my client doesn't have the flexibility that she has not to work. He's fortunate that he does have some flexibility with his employer, but he does need to work, and he should not be penalized essentially by losing an overnight or losing time with the child because of that, or losing an overnight potentially, and having this child subject to being moved back and forth more often. He has to have childcare during the day on Mondays, that is true, but he has a plan. Most parents need to work. He's no different. And it's nice that mom doesn't have to, but not everyone has that availability. She indicates she's breastfeeding. The child is 18 months old. The child is eating solid foods and milk and is not dependent on breast milk at this point. And not only would the Monday maximize my client's time with the child, but again, it's at least on the alternating week, less back and forth. So I don't think mom's arguments really have any merit to them, other than her saying dad has to use childcare as opposed to the child being with mom. And that's just simply not fair.
But Judge, we're not trying to take any time away from dad. I mean, their proposal is literally to take the child away from mom from 7:15 until 6 p.m. Dad works Monday, dad works Wednesday. So we're not taking a single hour away from dad. They're basically seeking to take that entire 7 a.m. to 6 p.m. away from mom and give them to grandma. My client has no problem with his parents. She says they're great grandparents, but she would rather, exercise the time, with her daughter.
It's a 14-hour time frame every Wednesday, if my math is right, versus extending that weekend at least every other. The 14 hours or so would be the same when he doesn't have the weekend, but it would give him additional time with the child in the mornings at least on those Mondays. So we stand by our request for the Mondays.
Does Mr. Stump, does he work on Mondays as well as Wednesdays? Or
Mr. Stump?
I work Mondays and Wednesdays, but there are times Mondays where I'm working remotely too. So I'm able to physically be there. Obviously, we still have someone to care for Briar, but it's a hybrid schedule that I'm on.
Well, what about Wednesdays? Do you work every Wednesday?
Yeah, I work every Wednesday, and those are tougher because of outages that I maybe get involved with longer hours and stuff like that. So.
All right. The court modified the recommendation, so fathers shall have alternating weekends, Friday at 5 until Tuesday at 7:15 a.m. and alternating Wednesdays. Maybe he's got Wednesday on the weekend, which he does not have the Mondays overnights. So again, fathers shall have alternating weekends, Friday at 5 till Tuesday at 7:15 a.m. and then the alternating weeks, Wednesday 6 p.m. to Thursday morning, 7:15 p.m., 7:15 a.m. Court ordered the parties complete the SMA program, and then also that there should be such additional parenting time as the parties can agree. Well, let's try this. Is it necessary that we review this in 60 days, Ms. Sills or Mr. Bruce? Do you think this could be an issue with the parties?
I think a review could be helpful to see how this goes.
Yes, Judge, I think it would be beneficial.
Okay. Do maybe late April or early May. How about April 30th at 3 p.m.?
That's fine.
I can do that. Lonnie?
All right. Ms. Sills, Mr. Patrick, please put a court review parenting time April 30th at 3 p.m. For the record, this matter is before the court for the purpose of reviewing parenting time with a one-year-old child of the parties. This hearing is being conducted via Zoom. President Attorney Ron Bruce representing the plaintiff mother, Margaret Smith. Ms. Smith, are you present on audio?
Yes, Your Honor.
All right, good afternoon. In addition, Attorney Christina Hills is present representing defendant father, Lonnie Stump, and Mr. Stump is present. And the parties have conferred with Ms. Patrick from the front of the court, who has provided the court the following recommendation that parenting time shall remain and continue as previously ordered. Parties shall continue to use app close. The parties shall appear back for court to review parenting time August 28, 2024 at 1:30 p.m. Court recalls dad's parenting time was alternating weekends, Friday at 5 to Tuesdays at 7:15 a.m. and alternating Wednesdays 6 p.m. to 7:15 p.m. Mr. Bruce, is this recommendation agreeable with your client this afternoon?
Yes, Judge.
Ms. Hills?
Yes, Your Honor.
All right. Have the parties completed the SMA program?
I believe my client has.
Believe so, Judge.
Is that correct, Mr. Stump?
That's correct. Yeah, I watched the videos and yep.
I did. Ms. Stump, did you complete the SMA program?
Yes, Your Honor.
Okay, good. All right, Mr. Bruce or Ms. Hills, you want to voir dire your respective clients this afternoon?
No, Judge.
All right. All right. Very well. Court will adopt the recommendation. Is everyone back here on August 28th at 1:30?
All right. Thank you very much. Thanks, Mr. Patrick.
Primarily, this hearing is being conducted via Zoom. Present is Attorney Alex Goldman representing the plaintiff mother, Jordy Schmitz. Ms. Schmitz is present. Is Joshua Gibson present on audio?
Yes, sir.
All right. Good morning.
Good morning.
An order was entered in January of this year, providing for parenting time schedule and also scheduling the matter for review today.
Yes.
That parenting time in the January order was for mother's parenting time. Is that correct, Mr. Goldman?
Yes, Your Honor.
Yeah, so the recommendation, the parties have conferred at length with Mr. Walker for the front of the court this morning. Mr. Walker has provided the fine recommendation. Mother shall have the following schedule, week 1, week 2. Week 1, mother shall have parenting time Monday, Wednesday, and Thursday from 5 p.m. to 8 p.m. Week 2, mother have parenting time Monday at 5 p.m. to 8 p.m., Wednesday 5 to 8, Saturday 5 to 8, and Sunday 5 to 8. The previous parenting time schedule shall continue until March 3rd, which is when week 1 will commence for mother. I'm sorry, March 11th. I apologize. So this proposed recommended parenting schedule, week 1 will start for mom next Monday, which is March 11th, 2024. Mother shall also have parenting time on Easter Sunday, which is March 31st from 3:30 p.m. to 6:30 p.m. Neither party shall disparage the other party or make any disparaging remarks in the presence of allow any third party to make any disparaging remarks in the presence of the minor children. No other family member shall be within visible range of the children during parenting time exchanges. Neither party shall discuss this case or allow a third party to discuss this case in the presence of the children. The minor child Jordan shall be allowed to keep a cell phone in his possession during mother's parenting time for emergency purposes. And finally, the parties will appear back before this court to review parenting time on May 7th, 2024 at 10:30 a.m. That is the recommendation. Mr. Goldman, is this recommendation agreeable with your client this morning?
Yes, Your Honor.
Thank you. Mr. Gibson, do you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting this recommendation?
At the moment, no, I do not.
All right. Mr. Goldman, do you wish to voir dire your client regarding this recommendation this morning?
No, Your Honor, but I do have 2 further issues.
Sure, go ahead.
We would like Ms. Sonicson Schmidt's boyfriend to be allowed around the children. There's no reason that he shouldn't be allowed to. And, you know, I realize that we're doing gradual increases, so that day is coming, and we would just prefer that it be sooner rather than later.
Was that discussed with Mr. Walker this morning?
It was. Yeah. Mr. Gibson does not agree.
Oh, okay. What is the boyfriend's name?
Chris Dotson.
You actually he has a case before you, Your Honor. The most recent order in that case allows him to have reasonable and liberal parenting time.
Okay. Mr. Gibson, do you have any objection to Chris Dobson being present during mom's parenting time?
Yes, I do.
Okay, why? What's your objection?
One, he has supervised visits in his marital home. He is still married. Our oldest son is terrified of him because of he feels like he can't even go out in the front yard and play in his own front yard because the man is always over there staring at him. It's not okay.
Okay. I mean, the children are 5 and 2. Is Mr. Dobson still married, Mr. Goldman?
Yes.
I don't know. I'm looking at a DS case. I'm sorry, I didn't pull that part of the file. I wasn't expecting that allegation to be made.
Yes, he is still married to Rochelle Dotson.
I'm seeing a custody and parenting time order in a DS case. I don't think that would be possible if he was still married.
They are still married.
Ms. Sonnenschein Schmitz, is Mr. Dobson married?
You're on mute.
You're muted.
My apology. They are currently going through their divorce.
All right. Does Mr. Dobson reside in your home?
Yes.
Well, that's wrong. It's this point in time, this is your parenting time. If Mr. Dobson needs to be there, then let's modify and reduce the parenting time. So we can address that further when we come back for the review, Mr. Goldman. Again, on May 7th, but this is parenting time for mom, not for Mr. Dobson. Mr. Dobson's married. Well, there's got to be some.
Thank you.
Not trying to preach morals, but come on, it's not appropriate in this court's opinion. So Mr. Dobson will add to this recommendation, Mr. Walker, Mr. Chris Dobson. I believe it's DOB-SON shall not be present during mom's parenting time.
DOT-SON.
Oh, Dotson? Thank you. Again, Mr. Gibson, if in fact Mr. Dotson gets married to Ms. Schmitz, I mean, that's going to be a whole different situation. You need to convince this court that he's a danger to your children. So that's just for the time being. You understand that? This can be revisited.
Yes, sir.
Mr. Goldman, you had one other issue?
Yes, I wanted to request that all further hearings be in person. I've made this request before. I understand the court's reluctance, but I think there's a couple egregious supporting factors. Members of Mr. Gibson's family or friends, I'm not sure who, have actually recorded friend of the court discussions. And furthermore, I do have screenshots of them texting him in the middle of those discussions. So we have off-camera participants, and I just think that having in-person hearings will ensure that that doesn't occur.
Well, Mr. Gibson, you should be in court by yourself, not with your uncles and aunts and your mother is telling you what to do.
Yes, sir. I haven't had anybody around, but I understand what you're saying. Yes, sir.
So they should not be, if it comes to court, if there's any documentation evidence that they're participating in proceedings, then the court will order in person. But at this point in time, Mr. Gomez, it's so much easier for the parties. The court finds, to be honest with you, the parties are more rational if they're separated. The intensity increases when parties are together face to face. And it obviously it's difficult too. The court can't have the friend of the court come up here to meet with the parties. It makes it difficult for the court, but the front of the court. So at this point in time, the court will deny the request for an in-person hearing. If we need an evidentiary hearing, then by all means, that'd be in person. But these reviews, Mr. Gibson, next time, will you appear on audio or on video? You understand that?
I currently don't have a front-facing camera because my phone is broken, but I have been working on getting a new camera. And my back.
Because I want to make sure that you're by yourself and you don't have other people in your room. So yes, go on by camera. They're not that expensive.
Yes, sir.
All right. So the only thing we're going to add to this recommendation at this point in time is that Chris Dotson should not be present during mom's parenting time. So if in fact Chris Dotson needs to come over at a certain time, then you need to let the child know that the child will stay with dad if Mr. Dotson needs to be present. I'm sorry, ma'am, you had a question?
Yes, I just have one question. It is my understanding.
Your Honor, is there any way that I can be in a breakout room with my client?
Sure. Well, let's have you talk with your attorney, Mr. Bowman.
We're back, Your Honor.
Okay.
Court is recalling memo page 2, Jordy Saxon Schmitz versus Joshua Gibson.
All right, the parties have returned to Mr. Gibson. Are you still present?
Yes, sir.
All right. Mr. Goldman, your client had a question?
Nothing further, Your Honor.
All right. But court will adopt recommendation with the provision that Chris Dotson not be present during parenting time. Mr. Gibson, obviously, that's an issue that could be raised again down the line in the future. The exchange will still occur, I believe, at Adams and 6th Street where you've exchanged before. So any prior orders are not inconsistent with this order will continue. We'll serve then that review date in May. For the record, this matter is before the court for purpose of reviewing plaintiff mother's parenting time. This hearing is being conducted via Zoom. President is Attorney Alex Goldman, representing the plaintiff mother. Ms. Sonneschen Schmitz and Ms. Sonneschen Schmitz is present. In addition, defendant father Joshua Gibson is also present. Good morning, everyone.
Good morning.
The parties have confirmed with Mr. Walker this morning from the front of the court, who has provided the court the following recommendation. The recommendation is that mother's parenting time looks like apparently be modified and to be on the Sunday parenting time shall be from 12 noon until 6 p.m. In addition, the mother's video chats and phone calls shall start at 6:30 p.m. It's not clear what days of the week that is or every day. Further, it's recommended that only the biological parent shall be present at the minor child's IEP appointments. Father shall contact his insurance company regarding the deductible to fix his cell phone camera as soon as possible. If the deductible is zero or at a reasonable cost, he shall have the phone repaired. The mother shall start her court-ordered video chats with the minor child. And that's the recommendation. Mr. Goldman, is this recommendation good with your client?
Almost, and I apologize for missing the phrasing. When it mentions IEPs, I think that should be expanded to include parent-teacher conferences and anything of the like. Other than that, we approve of the recommendation.
Okay. That's a point. Mr. Gibson, any objection that only the two of you should be present at your child's IEP appointments as well as parent-teacher conferences?
I mean, even though she's my wife, we are married.
Well, when she's not, if your wife is not the mother of your child, the decisions regarding your child should be between you and mother.
All day. She kind of knows a bit about the boys.
Well, but you should be, this is your responsibility, not her responsibility. She's a stepmother.
Okay. I understand that, Your Honor.
All right. All right, Mr. Walker, we can expand that only the biological parents should be present at the child's IE appointments as well as parent-teacher conferences.
Yes, Your Honor.
Add that language. Now, with respect to parenting time, is this the prior parenting time order, Mr. Goldman, was there was a week 1, week 2 parenting time? Will that continue, or is this simply just modifying Sunday parenting time?
It's continuing, and then we're just making one of the days, so the Sunday on week 2, an additional 3 hours.
Okay. Ms. Walker, we can clarify this. It's just for the court's reference going back on this. Maybe after Mother's Day, summer parenting time, Sunday parenting time, because it should be 12 noon to 6, and maybe just a prior parenting time order of March 5th shall continue. And what about the video calls? Was that supposed to be reasonable and liberal? Or is there any specific days of the week that video chats occur?
Just on the days that have the kids.
Okay. Right now, your phone is not working. Mr. Gibson, the camera is not working.
Sorry.
Mr. Gibson, right now, the video feature of your phone is damaged. Is that correct?
Hold on. On my phone, I'm borrowing. Hold on a second.
I turned it off.
You can see me, correct?
I'm sorry?
You can see me, correct?
No, we can hear you because there was not very clear on audio, so the audio is much clearer with you just putting on audio. I'm asking you, now we can see you. Right now, your cell phone, the camera version is damaged, is that correct?
Yeah, my front and back camera are damaged. I got to call my AT&T insurance and see how much the deductible is to get it fixed.
Okay. But right now you're borrowing someone's phone, correct?
Yes, sir. Yes, sir.
Was it your wife's phone?
I'm borrowing my mom's phone at the moment.
Does your wife have a phone?
Yes, but she's not here at the moment.
Well, I don't want to drag out these video calls for 2 months until you figure out the insurance. Can't you borrow some of your mother's phone or your wife's phone?
Yeah, I can always do that. I was just saying, until then, I do need to call and make sure that I can get my phone fixed. No.
Well, but that's a secondary issue. So I don't think this should not be contingent upon you figuring out your insurance. So perhaps we can eliminate the provision, Mr. Walker, about the phone. The video chat should continue as previously ordered. So either you make it happen, Mr. Gibson, and that'll give you some incentive to figure out your insurance. But in the meantime, borrow your mom's phone or your wife's phone.
All right.
Is that workable?
Yes, sir.
All right.
Your Honor, let me check with my client. Jordy, does that work for you?
Yep, that's fine.
And otherwise, I don't want there to be a 6-week delay for video calls, Mr. Coleman, because you're not getting an answer from his insurance company or he doesn't have time to contact them. There should be video contacts at 6:30. All right, so the prior parenting time order will continue. The only revision is that the video chats shall start at 6:30 p.m. and the mother's Sunday Parenting time shall be noon to 6 p.m. All right, Mr. Gibson, do you have any questions for the court?
I mean, I feel like pushing 6 hours. I mean, I was trying to work, but he still just wants 6 hours. Feel like it's pushing it a little extra. I was trying to meet in the middle somewhere, but it sounds like you approved it. So
No, I'm not. What again? This is your opportunity. If you believe this recommendation is not in your child's best interest, now's the time to address. You have 2 children, 5 and 2-year-old.
Yes, I think
Okay.
that we're a little fast, but her lawyer doesn't seem to think so.
I'm sorry. What was your first statement?
I said I feel like them going for 6 hours when they're only used to going for 3. Why don't we just push it up an hour and a half more? I'm trying to meet in the middle. He wants to keep it right at 6 solid. So I was showing my opinion out there.
Okay. Does this disrupt your children's meals or nap time or what?
I mean, nap time, possibly, but meals, I always make sure they eat. That's never a problem.
Okay, obviously what we're trying to accomplish here is that the minor children can spend as much time with each parent as possible to maintain that relationship. Of course, there'll still be the prohibition. Chris Dotson shall not be present during mom's parenting time. You understand that, Ms. Schmitz?
Yes, Your Honor.
So, I mean, he's got to, on these Sundays, he's got to be out of that home between the hours of noon and 6. You understand that?
Yes, Your Honor.
Is that going to be a problem?
Nope.
Okay, because one way we resolve that, we shorten the parenting time.
Understood.
And so let's give it a try, Mr. Gibson. If in fact, the court, you need to convince this court that it's not in the best interest of your child. So we're going to keep that restriction in place. Any prior orders not inconsistent with this recommendation will be continued full force in effect. Chris Dotson shall not be present during parenting time. If you find out that he's present, you need to bring it to the court's attention. We will reduce mom's parenting time.
Yes, sir.
Right. Anything further this morning, Mr. Goldman?
No, Your Honor.
Okay. Do you want to voir dire your client regarding this recommendation? Is it necessary?
I don't believe it's necessary.
All right. The court will adopt the recommendation. We're simply going to delete the provision about the fixing the cell phone. Mr. Gibson will make arrangements with his mother's or his wife's cell phone to continue the video contacts between mom and minor child. Now we'll conclude this hearing. You can all zoom out. Have a good rest of the day.
Your Honor, do we need to set an upcoming review hearing?
Do we need another review hearing?
I would request one, yes.
Okay, how many review? I mean, the court has a busy document, so we can't keep every case having a review every month. So
we could push it out 3 months, but I do just want to make sure that we are continuing to expand mom's time.
Okay. So we can add a review date. So it's sometime in
August.
Okay. We'll do that.
Okay, I have Tuesday, August 13th. It's totally open.
Hey, Alex.
Hold on. August 13th. Does that work with your schedule, Mr. Gorman?
It does for me. I don't know about Jordy.
Is there any way we could do a 2-month? Do it a little sooner so we can expand my time for summer? Do it like maybe the middle of July.
Sure. I have Tuesday, July 16th at 9:30 or 2.
9:30 works for me.
That works.
Okay, so Mr. Walker, if you can put in here the court review parenting time, July 16th.
Yes, Your Honor.
Mr. Gibson? Mr. Gibson, you had a question?
Yeah, I also wanted to bring up that I signed him up for summer school. I don't know if I would hope that his mom is okay with it, but I do also have the dates for his 3 sessions of summer school. If you guys
communicate that, hopefully you've already told mom about this summer school. You got to communicate those things.
I just got the dates today. I was going to tell you guys the dates.
Okay. Why don't you tell us the dates then?
First session is June 17th. through the 27th, Monday through Thursday, 8:50 to 3:05 p.m.
Okay, perhaps you can text that to her so she has something in writing.
I believe I already did text it to her, but I can retext it to her. That's not a problem.
Miss Schmitz, are you aware that he's got summer school? Do you have the dates and times?
Yes, he informed me after he enrolled him in summer school.
Okay, well, any objection to summer school? They should have advised you at the get-go. Any objection?
Nope, I don't object to it. I just would like to be informed before he makes decisions.
Yes, you need to discuss these things in advance, Mr. Gibson. So will this date in July, is that going to interfere with his summer school?
I mean, his second session is July 8th through the 18th, same times. And then the third session is July 22nd through August 1st, same times.
Right. But again, he doesn't need to be here for the court. Are you both here?
I just want to, that's all.
All right. What time on July 16th? So July 16th, 2 o'clock will be the review for parenting time.
Okay.
Again, unless he's got to be picked up at 2 o'clock.
Oh, I believe it's buses. I believe they still have buses in the summer, so I'll just pick them up at the bus stop.
Right.
Or have someone in my family go down and pick them up at the bus stop if I have court that day. At that time.
So please communicate with each other about these things. Right. So Mr. Walker put a review date then July 16th, 2 o'clock via Zoom. Okay. All right. Anything further, Mr. Goldman?
No, Your Honor. Thank you.
Right. The outclosed matter will send you a copy of this order, Mr. Gibson, and it would be a Zoom review on July 16th, 2 o'clock.
Okie dokie.
Okay. You can both zoom out.
Thank you.
Thank you. Bye.
For the record, this matter is before the court for the purpose of reviewing any outstanding issues. This hearing is being conducted via Zoom. President Attorney James Petrangelo, representing the plaintiff, Morgan Fader. Ms. Fader is present. In addition, defendant Father David Gross is also present. Good afternoon, everyone. And the court would note that the parties were before the court back on January 23rd. The court entered an order at that time referring the issue of custody and parenting time to the front of the court for recommendation. The front of the court has issued the recommendation. It appears that Mr. Gross did not participate in that investigation.
Your Honor, I believe today we've gone through everything with Ms. LaPrade. I believe the parties indicated they're in agreement with that. If I could try to state it, or she could, if it's not appearing on your screen.
There, I finally accessed that. I'm sorry. Thank you. The recommendation is that follow shall have specific parenting time as follows, namely every weekend, Friday at 4:30 to Sunday at 6 p.m. The parties shall continue to exchange the minor children at the Sumter Police Department. Both parties shall be entitled to 2 weeks of uninterrupted summer vacation. Is that consecutive weeks or non-consecutive weeks?
What would you prefer, Mr. Gorlitz? If we have it say it's not to be consecutive, that means you wouldn't be away from the kids more than a week at a time. Is that what you'd prefer?
Sure. Yes.
All right. Let's say non-consecutive, uninterrupted.
Okay. Mr. Brad may just add the words, the parenthesis after that, non-consecutive. If parties agree to consecutive, that's fine. But if there's a dispute, that'd be two separate non-consecutive weeks during the summer. Presumably, the parties will give the other reasonable notice. It's further recommended the mother should have spring break 2024, Halloween 2024, and Thanksgiving 2024 to make up for some holidays that she has missed. The issue of child support should be referred to the front of the court for a formal investigation recommendation, with each party having 21 days in which to object. The recommendation, the effective date for that child support, however, shall be December 1st, 2023. There should be no disparaging remarks made by either parent toward the other in the presence of the child, or allow any third party to make any disparaging remarks about the other party in the other parent in the presence of minor children. The communication between the parties shall be only regarding the minor children. And finally, father shall pay the sum of $2,500 to mother within 7 days to reimburse her for taxes. Finally, both parties shall complete this small program. That's the recommendation. Mr. Petrangelo, is this recommendation agreeable with your client, Ms. Fader?
It is, Your Honor. I believe it also indicates they'd have joint legal custody, physical custody to mother. He's to pay. Oh, you did have the tax money, $2,500. I believe you did state that. Yes.
Yeah, 20, it does indicate, and I apologize, it does indicate the parties shall share joint legal custody of minor children, physical custody to the plaintiff mother, specific parenting time for father as stated, and further that father shall pay to mother the sum of $2,500 within 7 days of today's date to reimburse her for the taxes.
That's all agreeable.
All right. Mr. Gorlitz, you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting the recommendation?
No, sir.
Do you have any questions for the court?
No, sir.
All right. Ms. Petrangelo, do you wish to voir dire Ms. Fader? Is it necessary? She did obviously participate in the discussions, but I'll leave it to you.
Just briefly, Ms. Fader, have you heard and do you agree with the recommendation?
I agree.
That's sufficient, Your Honor.
All right. All right. Court will adopt the recommendation. Thank you, Mr. Pratt and Mr. Petrangelo. And the court will applaud you as parents for reaching your own agreement. It's there's got to be some flexibility, so please communicate, and especially what weeks that you want to choose for the summer. Notify the other as soon as possible, so there's no conflict, unnecessary, and create unnecessary conflict.
Yes, sir.
Yes, sir.
All right. Good luck. I'll conclude this matter. You can all zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank
Your
you.
Honor, I'm going to upload the corrected recommendation that has the.
For the record, this matter is before the court on the plaintiff's motion to modify custody, parenting time, and child support. This hearing is being conducted via Zoom. President is Attorney Scott Musson, representing the plaintiff moving party, the plaintiff and Rocky. Ms. Rocky is present. Is Dustin Bayer present on audio?
Yes, sir.
All right. Good afternoon. The court has received a recommendation that this hearing be adjourned to April 24th at 1:30 so that you can consult an attorney. Is that correct?
Yes, sir. Please and thank you.
All right. That work with your schedule, Mr. Musson. Will you be appearing on that date, or is your limited appearance expired?
I will appear on that date.
Okay. One of the questions the court had, this follows a paternity complaint. Was there an acknowledgement of paternity ever executed by Mr. Bayer?
I don't think we did a paternity test.
Okay, well, no, I'm asking, did you sign a document? It's called an AOP, affidavit of paternity. At the hospital, when the child was born, did you sign something saying that you were acknowledging you were the father of this child?
No, sir, I did not.
All right, and Ms. Zaraki, I'm sorry, actually, this case was started by the special prosecutor, wasn't it appears back in January 12, 2023. I apologize. So it does appear that there is a custody order entered in March of 2023. Oh yeah, this order of March 29, 2023 does indicate paternity is established by acknowledgement. So you must have signed a document. Mr. Musson, is your understanding that there was an acknowledgement of paternity previously executed?
It was my understanding. I was not involved in the initial part of this case, only for this motion. I just came into it. But I think a judgment affiliation was done on March 30th. I don't know whether that was signed and consented to, or if that was just a finding by the court and entering of the judgment.
So does it look like referee order? Ms. Rocky, do you recall, did Mr. Bayer sign a document at the hospital called acknowledgement of paternity where he signed acknowledging he was the father of my child Mason?
Not at the hospital, no. We had signed something and I gave it to him to give it to you guys. I don't know what he did with it.
No, it doesn't come to the court, it goes to Lansing. Do you have a copy of Mason's birth certificate?
Somewhere, yes, I do.
Okay, does it have a father's name on there or is it blank?
No, it's blank. But he did have one of those papers and I told him to take it to you guys. Obviously that didn't happen.
It doesn't come to the county, it doesn't come to the county clerk, it goes to the state of Michigan.
No, I'm saying, I know, but I'm saying is we signed that paper and I gave it to him to turn in.
I know, just we said if you give to us guys, it doesn't come to us guys, it goes to Lansing.
Sorry, sir. What I meant was we had signed it, yes, but I gave him the paper and told him to turn it in. I don't know if that was done or not.
Miss Rocky, I'm gonna make a note before when we come back April 24th. Will you track down the birth certificate and find out whether or not the Mason, there's a father reference on the certificate.
There's not a father on the birth certificate.
Okay. Perhaps it could have been some error.
There, what I said was on March last year, there was a paper set. We signed it. I had given it to Mr. Baird to turn in, and it didn't get turned in.
I understand. Mr. Walker, are you still present?
Yes, Your Honor.
Mr. Walker just had a question because I'm looking at it. Looks like Jack Vitale entered an order as a special prosecutor in March of 2023.
Yes, Your Honor. There was an order of affiliation.
Roughly near pass, yes. It makes reference in there in terms of statutory acknowledgement. Does your office keep copies of those acknowledgement? How do we know that there's acknowledgement?
The acknowledgement is not an AOP and not an affidavit of parentage. That means what it's supposed to mean is that parties acknowledged on the record with the referee that that Mr. Bayer is biological and legal father of the minor child. That's all that does. So there was no paternity, there was no DNA testing. They just acknowledged without DNA testing.
Okay. So DNA testing only required if there's a revocation of paternity then. So in other words, if somebody acknowledges, that's sufficient.
Yes.
All right. All right. So Ms. Rock, you do acknowledge that Mr. Bayer is the father of Mason, correct?
Yes, sir.
And Mr. Bayer, you acknowledge you're biological father of the child Mason?
Yes, sir.
All right. Well, thank you, Mr. Walker. I guess that clarifies it. Yes. It's probably just a verbal acknowledgement that the parties acknowledge that. And yes, they don't. DNA is not required unless there's a revocation of paternity sought. All right, so that clarifies that for the court's notification. Okay, Mr. Bayer, do you have a mailing address? It's alleged that you're homeless. Are you getting mail at this address on North Telegraph Road?
The address should have been. That's where all my mail goes to.
Well,
Your Honor, the front of the court does have the address that Mr. Bayer just mentioned.
Okay. All right. Mr. Bayer, you can modify for your records as new address for Mr. Bayer. That's the address, the legal address on file at the front of the court. And once you state the address once again, Mr. Bayer, it's 18. All right. Thank you. So do you live at that address with your relative?
No, sir. I live in a motel.
Okay.
I pay $300 a week here.
All right. It's not a great place to have a parenting time with the child in a hotel room. So hopefully you can find some housing when we come back on April 24th. Okay. All right. You'll be mailed a copy of this notice. Mr. Bayer will be back here to make an appointment with the attorney as soon as possible. We'll be back here April 24th at 1:30.
All right. Thank you, sir.
You're welcome. All right. Thank you, Mr. Musson.
All right. Thank you, Your Honor.
Welcome.
There you are. Yeah, definitely not being fair. Let me shut this off.
I put the new one up, Your Honor.
Thank you.
I'm not sure he's going to call back in. He was pretty agitated when I put him in the breakout room, so I'm not sure he's going to call back in.
Also, Ms. Sells and Mr. Rob can text him to tell him the court's waiting for him. I think it's important that he hear the order of the court.
Heather, are you able to message him?
I will try.
You can just let him know that the court is waiting on him to, if he can reappear, please.
He said he's trying to come back.
Thank you.
Heather Strong versus Charles Strong.
For the record, this matter is before the court on the plaintiff's motion to modify custody, parenting time, as well as for exclusive use of the marital home. This hearing is being conducted via Zoom. President is Attorney Christina Hills, representing the plaintiff, petitioning party Heather Straub. Ms. Straub is present. Is Charles Straub present on audio?
He needs to unmute himself.
You need to unmute yourself, Mr. Straub.
Okay, yes. It kept, my phone was glitching out. I apologize desperately. I am so sorry.
No problem. No problem. Thank you, Mr.
just couldn't
Straub,
get it to go
for texting. Not a problem at all.
No problem.
All right, the court stated this matters before the court on the plaintiff's motion to modify custody, parenting time. Not to modify, but to enter an order of custody, parenting time, exclusive use of the marital home. Both parties are present. Mr. Straub is no longer represented by attorney Suter. And Mr. Straub, you're aware there's a mediation scheduled for next Wednesday, April 13th at 1:30 for Mr. Walker. You have that on your calendar, correct?
Yes, sir.
March 13th. Okay. I know that was scheduled and when you had an attorney, but that's still on. So after you're done with that mediation, then you'll appear before the court for further action, whether you need to set a hearing date. Hopefully the two of you have your own agreement, but the court wants to keep that mediation on as scheduled. And it's not binding. It's just an opportunity to find some middle ground. I think you'll find it to be very helpful. So make sure you appear with Mr. Walker, and you have his Zoom ID number, correct?
Yes, sir.
All right. Okay. The recommendation this afternoon of Ms. Patrick is that mother be granted exclusive use of the marital home. Defendant Charles Straub will provide complete and provide to Ms. Hill, Attorney Hills, their domestic relations financial form. I'm surprised that was not done with the assistance of Attorney Suter. That's usually should be done right at the get-go. I don't know whether she completed that, whether the attorney has that. You get that back from Ms. Straub. If not, do you have that form?
No, no, and that was why I let her go, because she wasn't working with me. And I've contacted her multiple times about where she left off in the case and what forms in which she has given, and they've ghosted me, and they will not talk back with me about that.
All right. How do Miss Hills? Can you scan and email to Mr. Straub the form they can complete?
Yes, I indicated to him that my office would be sending him a copy of that form, that it needed to be completely filled out, attachments as necessary, and that it needed to be notarized. So
okay.
We'll also send him an email with the form attached to that effect.
All right. So look for that today, Mr. Straub. We've got that's a quick turnaround time. You've got to work on that this weekend. Get that back to Ms. Hills the day before the mediation.
Absolutely. I will get on that. I asked my lawyer many a times where she had left off, and I didn't know, and I apologize for me not being prepared with that. And I'll have it for you promptly.
All right. Ms. Hills, you'll provide to Mr. Straub Ms. Straub's financial form as well?
We've already sent it, yes. You should, if he hasn't received it, he should be getting it any day.
All right. Do you understand, Mr. Straub?
Yes. Yes, I do.
You'll be receiving probably any day the completed form that has been completed by your wife, Heather. She and Ms. Hills are entitled to one that's completed by you and notarized. So please look for that. I suggest that when you get it to scan and email, you print it off, work on that this weekend, get it back to Ms. Hills the day before mediation, maybe March 12th, so you can mediate and be prepared March 13th at 1:30. I know you moved out of the house and moved back in. You understand the recommendation, Mr. Straub?
Sir, to be honest with that, I never moved out. And in that 2 weeks, my kids were actually on break from school. And not only was I was home alone with them during their whole break. I was never not there for 2 weeks. I don't know where I have picture evidence, and I will submit it when we get to the trial part of this, where I was there every single day.
All right, Mr. Straub, let's assume that you never moved out, that you're there every day. I'm going to take that for granted. You're there every day. The allegations that you're being verbally abusive, you're creating a conflict in the home, chaos, that you shattered your child's phone, you're calling mom names. That's totally inappropriate for the presence of those children. So what do you say to those allegations? That's enough to get her exclusive use of the home, sir.
They are definitely not true to any extent. And the phone was taken away because I found where my daughter was talking about suicide and contemplating suicide with other children. And I had sent all this evidence to my lawyer, and I don't know why she didn't get this to the court. All of this. Okay, I have all of this evidence.
Mr. Straub, taking the phone away is one thing, but shattering it in the presence of the child is another thing.
I have the phone to prove to you. It doesn't even have a scratch on it. I did not shatter a phone. It has evidence on it of abuse from my wife to my daughter, and it has evidence of my daughter who's 11 talking about killing herself, and her friend talking to her about killing herself. And there were some old men contacting her. And they were like, "Don't tell your mom or your dad." And I was just concerned about the not even the kind of stuff about between Heather and my daughter, but mainly the stuff about the suicide and the murder and the killing. And then my daughter had an episode, and I have a video of it, where she had a panic attack because I took the phone, because she was going to see about the suicide and the bad stuff on the phone. And she had a panic attack. She was just angry. And I have the video. And my lawyer was supposed to submit this, and I'm not sure why she wouldn't take it from me. And I have text, this is why she got fired. And when these videos come out, they will answer and prove that not one of those allegations is true.
Mr. Straub, if your daughter was talking about suicide, the proper thing for a parent to do is to sit down with their mother, the other parent, and say, I've got some concerns here. We need to get our daughter in counseling. Did you do that?
Yes, sir. Yes, sir. And my wife actually...
Hold on, Mr.
Yes,
Straub. Mr. Straub,
sir.
you talked with Heather and said, I've got some concerns. Our daughter's with suicide. We need to get her in counseling. You told that to Heather?
I texted it to Heather, and I have the text.
Okay, I guess we need to interview, put your children in the middle of this. I mean, you're saying it never happened? Ms.
This never
Straub
happened.
is alleging that these did happen. Do we need to interview your children? Do you really want to put your children in the middle, Mr. Straub?
At this point, I think you need to see my videos, and yes, you need to interview the children. Yes, because this is not true by any sense of the word. It's actually backwards.
Okay, you better present your videos to Mr. Walker. The court's going to hold off the exclusive use of the home, Ms. Sills, until the mediation on Wednesday. And then when the parties appear before the court then will address that.
Your Honor, I would ask...
Mr. Straub is denying all these allegations. I don't know what to do, whether to interview the children between now and then.
Your Honor, this is clearly not a tenable situation between the two of them being in the same home at this point. Not only per my client did he move out after he was served, or at least wasn't staying in the home, whether he wants to use different verbiage or not, but he has recently left again. He has not been in the home since February 22nd. He said, told us he was staying in his car. My client has reason to believe he's staying with his parents, but it is simply not right for my client to have to deal with the prospect of him simply coming and going as he pleases. They have the right to some peace and some stability as well. February 22nd, after the court's personal liberties injunction was entered on an ex parte basis, he was at the home. That's the day he ultimately left. He was harassing her, mocking her in front of the kids. He dumped out the hot chocolate that she'd made for the children for breakfast that morning. He dumped water all over her laptop computer, dumped coffee all over the kitchen counter. This is the type of thing that my client is dealing with when he's there, and it's all happening in front of the children. So I would ask the court to please order exclusive use of the marital home for my client. He's not even there at the moment, and address that at a review hearing following mediation if we're not successful with mediation.
All right, Mr. Straub, what about that? What about the incident of dumping the hot chocolate, the water? How about it's alleged that you've not been living in the home? Okay, you didn't move out. You made a different terms of words. Are you sleeping there every night?
I can explain all of this.
So, are you sleeping there every night, Mr. Straub?
Not since lately, because you can see it. I was involved in a drive-by shooting.
What about the hot chocolate incident?
That was not true. That didn't happen. I have a video. I recorded that entire incident from the beginning to the end. And I actually have a compromise I can make. To defuse the situation, I'm willing to actually let her have the exclusive rights to the home. But I want this to be duly noted when we do actually get to trial, because I have proof and videos that are contradictory to everything she's saying. And instead of getting us all upset and causing all of this, since I have so much evidence, I think that when we get to show the evidence, it'll just be clear. And if you don't want me there because of what she's saying, I mean, I'm fine with that, because like I was going to tell you, as I was involved in a shooting at work, and ever since then, my nerves are kind of shot. As on the same day as the cops were called with me and her, later on that day, I was involved in a drive-by. I was shot by some kids with a machine gun ball, and they're going to get charged with felonies. But it shook me up pretty good, and I'm just with all this and that, I'm having a hard time just not being freaked out by it, not being anxious, but that's why I haven't been in the home the last week, and they're still investigating who shot me. They haven't found out who they were, and it was all caught on video. And it was a drive-by shooting, and they waited till I walked out of my job, and I walked to my truck, and when I turned my back, I was attacked by someone wearing ski masks, 2 men, and they did a drive-by on me with a machine gun type thing that shot ice balls, and they shot me with a bunch of ice balls. And the police were involved, and they said they're going to charge him with felonies. but I don't think they've been able to catch them. I know they have their car and their license plates, but yeah. So I've just been nervous, because I don't know who was involved in that. Like, it was the same day that me and her had an altercation. I've been nervous to go home because of the drive-by shooting thing. And I'm just saying, I don't, and they'd have to talk to the police about it much further. They're still investigating the entire thing.
Well, that gives all the more reason we don't want to put your children in jeopardy. If someone is after you, Mr. Straub, we don't want them coming to your children's home and shooting guns at
what if Heather
children's
had
home.
it? What if Heather did it?
Well,
she has everything to gain.
All right, Mr. Straub, you've agreed. So the court will order that and grant Heather exclusive use of marital home. You need you need a box of clothing. Can Mr. Straub box up some of the basic clothing that he has at Ms. Sales?
And she can drop that at my office and he can pick it up.
Okay, when can that occur? Maybe Friday?
It would need to occur between 8 and 12. My office is closed. We work remotely on Friday afternoons, but if you can be there between 8 and 12, she can have the box to us. Correct? Is that correct, Ms. Straub?
Yep.
Okay, Mr. Straub, can you be at Ms. Hill's office or have your parents or somebody stop by and retrieve some of the box of basic clothing?
Yeah, that's fine.
Okay, your office is not open afternoon, so plan on Friday. Make a mental note, Friday of this week, that's March 8th, between 8 a.m. and noon. If you're working, have your parents pick that up. But yeah, you can get all your videos together in any event. Of course, so the court will in fact adopt this recommendation. Plaintiff mother's grant exclusive use of marital home. With that, if Ms. Straub feels more comfortable changing the lock, she can do that, Ms. Hills.
Thank you.
Mr. Straub, that doesn't mean she gets a home. She just has exclusive use of it. You understand?
Yes. Yes.
If in fact she didn't vouch,
that was kind of what I was confused about.
If in fact she doesn't vouch your interest, then obviously it'll have to be liquidated and sold. But we'll take one step at a time. The things we're going to talk about in mediation are property settlements. Ms. Hill, just for the court's information, there's obviously real estate to be divided. Is that correct? Personal property.
Real estate. It's my understanding. I didn't look at all the property issues for today's purposes, but I believe my client owned the home prior to the marriage. So there's an issue of what constitutes Mr. Straub's marital interest in the property. Some personal property issues. I believe there are retirement benefits which would need to be addressed, as well as the custody parenting time. I don't believe alimony or spousal support should be an issue, but I'm not certain what Mr. Straub is requesting.
Well, what about, is there a significant unsecured debt like credit card debt that needs to be divided?
I don't believe is it, Heather?
Not significant, but there is credit card.
Okay. Okay. All right, Mr. Straub, do you have any questions?
And I'm concerned about our
I'm sorry?
Yes, sir. I am concerned.
You're breaking
about
up,
our
Mr. Straub.
taxes. Me and her file mutually with our taxes. I am concerned about it's about our taxes. Me and Heather's taxes. Are we about filing those?
Okay. You can talk about that on Wednesday of next week, the mediation.
Okay.
You normally would divide the proceeds, or the best you can do with the proceeds, if you get a refund, is pay off the credit card debt.
Now, can I request that she pays for the lawyer fee? Because what I've paid in the lawyer, and my lawyer did request that. And also, can I still get a chance to maybe get a lawyer with what happened with mine?
You can get a lawyer at any point in time. You get a lawyer at any point in time, but no, there's no, your attorney's not right here to request attorney fees, so no. Ms. Straub is not going to pay for your attorney. Anyway, but if you want to get another attorney to appear with you on Wednesday, that's fine. Or even if you have any, at least consult an attorney. It's probably wise to at least consult an attorney. The attorney can give you some idea of what to expect.
Yes, sir. I had hired an attorney and I paid them $7,000. And then they took all the information and did not give it to you. So I'm going to have to sue them too for what has happened here. They did this entire case and then for me. And then I paid them $7,000. I have all of the bills and all of the where I can show itemized everything that she did, and she was supposed to turn into me and she did not.
Well, Mr. Straub, you signed an agreement that she could withdraw. You should have not have signed that until you got a refund of your retainer or got some of your documentation, or just said, no, I want you to stay in the case.
Yeah. It was my fault. I'm not, I needed a lawyer because I'm not good at that stuff. So they tricked me. So yeah, I guess I'm going to eat that one.
Okay, so again, pick up your box.
I'm not a smart guy.
Mitchell's office on Friday, March 8th, between 8 and 8 and noon. You cannot go over to the house. You understand that? And then
Yes,
we'll
sir.
talk to you after your 1:30 mediation with Mr. Walker and get that financial form to Miss Hills by the day before. Right. Anything further this afternoon, Miss Hills?
My understanding the court will review this after the mediation.
Yes. We got it in our doc. We'll have the file up here.
Very good. Thank you.
And if Miss Robbins wants to change the locks at home, she can do that at this point in time.
Okay. Thank you very
All
much.
right. Right. That'll conclude this matter.
Awesome.
We'll see you then on
Thank you.
Wednesday afternoon, Mr. Straub.
Okay. Thank you.
You're welcome. Right. That'll conclude this matter. You can all zoom out. Thank you, Miss Patrick.